All right, y'all, man. So we back, man. The DA sent the response. You know, I've been waiting on this. I was having, I don't want to say hell, but I was having a little trouble in the beginning trying to send this off. I think I was a little bit too early on the complaint that I sent because the letter that I sent on January 23rd, January 23rd, DA hit me back. Friday night. It was 10 o'clock because I had woke up to go use the restroom and it was 12. And I checked my email, and guess what? The DA sent his response. So I don't want to take all day, but we got to get into this. I just want to tell y'all that I'm live, bro. I'm live right now. This is gonna be a long little sector right here because we have the DA response. Got to go over the letter, and then I also have to get into my Chat GPT stuff. You know, we got to use Chat GPT. That's the friend right there. That's the homie. So let me go and get into the response from the DA. So, mind you, like I said, I woke up, it was like 12 o'clock. So it says, Dear Sir, it says, please see the attached letter regarding your public information request. It says, you will receive a copy of the district attorney's office brief when it is submitted to the attorney general's office. You playing? Hey. You will also receive a copy of the attorney general's decision when it is issued. So, hey, the ball is in my court, man. Let's play ball. So then it says, please note that further action on your request will be processed by outside counsel, Olsen and Olsen. Please be alert to emails and other communications from Olsen and Olsen regarding your request. In the meantime, please clarify the following part of your request. So, y'all remember, I told y'all before I actually went to trial, I went to court, and we was waiting on DNA to come back, right? The DNA to come back. So my lawyer wound up going to the back to go see when DNA came back, and then she came back out and was like, "Hey, Jonathan, they didn't find DNA on the girl. It's almost over. We have to wait to just see the judge right now, and then it's almost over, right?" So I sat down, waited for the judge. Judge called my name. I went up there. Judge was like, "Hey, what you got?" So if you don't have anything, I'm about to let this case go. DA was like, I need more time. He granted more time. And then a few weeks later, my DNA, right, was under the girl's fingernails. So yeah, it says, in the meantime, please clarify the following part of your request. It says, any records created or received during the period in which the state requested and was granted additional time for DNA testing prior to trial. That's what I pretty much just told y'all. So they wanted me to clarify that. So I actually clarified that, but we'll get into that later. Then it says, please specify what types of records you are requesting for that time period. For example, emails between the DA's office and the DPS regarding the DNA testing, etc. Says if we do not receive a reply to this request for clarification or narrowing within 61 days, the underlying request is considered withdrawn. Please respond to my email. Thank you. Now, you know, I sent that email the next day. Come on, man. Come on, bro. You're not going to play me, dog. Hey, we moving forward, bro. We ain't got time to be playing no game with these people. You know what I'm saying? I also want to read you guys the briefing, part 2 of the district attorney's response. So, like I told y'all before, they had 10 business days to respond to my open records request. This is the law. This is law. This is not me just freestyling. This is the law. So it's the Public Information Act, right? Promptly produce records. If they want to withhold anything, they must ask Texas General Attorney for ruling. Within 10 business days of receiving request, they must notify you that they sought the ruling. So this is pretty much what happened. So let me tell you guys, this is pretty much what they did. They contacted the Attorney General for me, on me, right, on the records. So it says, Dear Attorney General, the Galveston County District Attorneys request a decision on withholding information pursuant to a Public Information Act. By copy of this letter, GCDA is notifying the requester we are requesting a decision from the Attorney General's office. GCDA contains the requested information. Other than basic information is expected from public disclosure pursuant to following provisions. Got it a little small right here. So then it kind of got a couple of laws. So it says privacy, Texas govern 552-101 and common law, privacy and constitutional privacy, essay assault case. And it says attorney, work product and communication privilege, Texas govern code 552.111. Then it has, it has a reference, and then it says date of birth, common law practice. It says social security numbers, motor vehicle information, driver's license, plate numbers, VIN numbers, still giving you little codes for that. Then it says originating names and addresses for 911 calls. Then it says this request for decision is made within 10 business days or receiving the request of information. GCSO will submit hold on, I'm trying to see y'all. Hold on, bear with me. A brief stating why the above stated exceptions permit without withholding the request information with a copy of the requested information or a representative sample thereof within 15 business days of receiving the request for the information. Thank you for your consideration. If you should require more information, please do not hesitate to contact us sincerely. The Assistant District Attorney of Galveston County. So, man, mind you, we're not looking for license plate numbers, social security numbers. We already know the identity. I know all these things. I don't know I don't know all those socials and all that there. But pretty much, that's not what I'm looking for. So I just feel like they really just don't want me to have what I need to move forward. You know what I mean? I need communications. I need everything. I just really want anything pertaining to Stephen Adam Vincent. I want communication. That's all I want. Like, I don't care about what they trying to hide. But of course I don't want to say they hide anything. Let's just say we don't know, right? But we want the info so we can dig deeper and I can clear my damn name. All right, y'all, man. So part 3 of the district attorney's response. So of course I use my friend ChatGPT, and that way I can break it down a little bit more because like I said before, everything is vague, man. You don't really know what things mean or what it's really saying until you actually know, right? So it says what their email means. Plain English. The DA's office has done 2 things. A, they admitted your request is active. They did not deny it. Instead, they send it to outside counsel, Osa and Osen, indicating they will be asking Texas attorneys generals for ruling on what they must release. It says that means your request is officially in motion. B, they are asking for clarification. This part, please clarify the following part of your request. Any records created or received during the period in which the state requested and was granted additional time for DNA testing prior to trial. It says they want you to be more specific about what kinds of records you are seeking in that time window. Says this is normal. It's not a resistance. It's a procedural step. Says C, the 61-day warning they added. If we do not receive a reply within 61 days, the request is considered withdrawn. That was done the next day. It says that standard TPIA language says you must respond, but it should be a tight, precise clarification. It says, should you respond? Yes, absolutely. It says, and you should respond narrowly and strategically, not broadly. Say what you are really looking for in that time period you want. Hold on. What you are really looking for in that time period, you want emails, memos, DPS communications, lab reports, internal notes, anything showing when the DNA story changed, exact response you should send. Here is a clean professional clarification email. Woo woo. So let's get into the email. You feel me? So it says, thank you for your response. I'm happy to clarify the portion of my request concerning records created or received during the period in which the state requested and was granted additional time for DNA testing prior to trial. It says for that specific time period, I'm requesting the following type of records: emails or written communication between the district attorney's office and the Texas Department of Public Safety Crime Laboratory regarding DNA testing in my case. It says any supplemental or amended DNA laboratory reports received by the district attorney's office, internal memoranda, notes, or correspondence discussing the status of DNA testing, retesting, or reinterpretation of DNA results. It says request by the district attorney's office for additional testing, reanalyzing, reanalysis, my bad, y'all, or review of DNA evidence. It says any communication or records referencing fingernails, DNA, mixture interpretations, or changes in DNA conclusion. It says any records reflecting the reason additional time was requested from the courts. This clarification is intended to narrow the request to communications and records directly related to the status, analysis, or interpretations of DNA evidence during that specific time frame. Please let me know if any additional clarification is needed. So that's pretty much what was sent. And now I'll sit back and I wait for a response from the DA and see what he say about my request. You know what I mean? Maybe he'll say okay. Maybe he'll want more of a clarification. I don't know, but I have time. So on to the next part.